Introduction. In 2019, New York State enacted comprehensive reforms to its criminal justice system, aiming to enhance fairness and transparency. A pivotal component of these reforms was the overhaul of the state's discovery laws, which govern the process by which prosecutors disclose evidence to defense attorneys. While the intent was to create a more equitable system, the implementation of these reforms has led to significant challenges and unintended consequences that continue to affect the state's legal landscape. Background of the 2019 discovery law reforms. Prior to the reforms, New York operated under what was often referred to as the blindfold law. Under this system, defendants frequently remained unaware of the evidence against them until the eve of the trial, hindering their ability to mount an effective defense. This lack of transparency was criticized for contributing to wrongful convictions and prolonged pre-trial incarcerations. The 2019 reforms sought to address these issues by mandating that prosecutors disclose all relevant evidence within a stringent time frame, typically 20 to 35 days after arraignment. This shift aimed to level the playing field, ensuring that defendants could make informed decisions about plea deals or trial strategies. The reforms were part of a broader movement toward criminal justice reform, reflecting a growing consensus on the need for greater transparency and fairness in legal proceedings. Implementation, challenges, and case dismissals. While the reforms were lauded for promoting justice, they also introduced significant challenges. Prosecutors found themselves burdened with the obligation to gather and disclose vast amounts of material swiftly. This encompassed not only evidence directly related to the case, but also peripheral information, such as disciplinary records of officers involved, regardless of their relevance. The sheer volume of required disclosures strained resources and, in many instances, led to procedural oversights. City and State New York. One of the most alarming consequences has been the surge in case dismissals due to these procedural lapses. For example, in New York City, the rate of criminal case dismissals escalated from 41% before the reforms to 62% in 2023. This sharp increase indicates that more than half of the cases were dismissed, often because prosecutors, overwhelmed by the new requirements, failed to meet the stringent deadlines or overlooked minor details. Such technicalities, while seemingly minor, have profound implications for victims seeking justice. Impact on domestic violence cases. Domestic violence cases in particular have been disproportionately affected. Advocates for survivors have observed a troubling trend where cases are dismissed over minor procedural errors, leaving victims without legal protection and emboldening abusers. In a letter addressed to state legislators, organisations supporting domestic violence survivors highlighted that the current law has led to record numbers of dismissals on technical grounds, depriving vulnerable individuals of urgently needed orders of protection and justice. Governor Kathy Hochul's proposed amendments. Recognising these challenges, Governor Kathy Hochul proposed amendments to the discovery laws in her 2025 State of the State address. Her proposals aim to prevent case dismissals over minor technicalities and adjust penalties for evidence-sharing violations. Specifically, the reforms seek to decouple discovery compliance from speedy trial requirements, allowing for more judicial discretion in addressing discovery violations. This means that not all procedural errors would result in automatic case dismissals. Instead, remedies would be proportionate to the severity of the oversight. Debate and opposition. However, these proposed changes have ignited a heated debate. Proponents argue that the amendments are necessary to ensure that victims receive justice and that perpetrators are held accountable. They contend that the current system, while well-intentioned, has swung too far in favour of defendants, allowing them to exploit technicalities to evade prosecution. District attorneys from across New York State have endorsed Governor Hochul's plan, emphasising that the reforms will streamline the discovery process, reduce delays, and prevent automatic dismissals that hinder justice. New York Post. +5. timesunion.com. +5, nicenated.gov. +5, Governor Kathy Hochul. On the other hand, critics, including public defenders and criminal justice reform advocates, argue that the proposed amendments could undermine defendants' rights and roll back the progress made in ensuring fair trials. They caution that easing the stringent discovery requirements might lead to a resurgence of trial by ambush, where defendants are unprepared to counter evidence presented against them. These advocates emphasise that robust discovery laws are essential for due process and that any dilution could result in wrongful convictions. They also point out that issues leading to case dismissals often stem from systemic problems, such as underfunded prosecutor offices and inadequate training rather than the discovery laws themselves. Legislative response. Legislative leaders have shown resistance to the proposed amendments. Both the State Senate and Assembly excluded Governor Hochul's suggested changes from their budget proposals, indicating a reluctance to alter the current discovery framework. This omission sets the stage for a contentious negotiation as the budget deadline approaches, reflecting the deep divisions over how to balance the rights of defendants with the need to protect victims and uphold public safety. Public discourse and protests. The debate has also spilled into the public arena, with protests and rallies highlighting the contentious nature of the proposed reforms. In the Bronx, advocates gathered outside the county courthouse to oppose Governor Hochul's efforts to amend the discovery laws, arguing that such changes could erode defendants' rights and lead to unjust outcomes. BronxDefenders.org. Conclusion. The crux of the issue lies in finding an equilibrium between ensuring defendants' rights to a fair trial and safeguarding the interests of victims seeking justice. While the 2019 reforms aimed to rectify systemic injustices, their implementation has revealed significant challenges that require careful consideration and balanced solutions. As New York continues to grapple with these complex issues, the ongoing debate underscores the need for a criminal justice system that is both